The thing about this opinion is that's so incredibly like I feel like I'm fucking taking crazy
Well, it's
pills.
gaslight. I mean, it's gaslighting at its finest.
100%, because he's like they're like we're not striking down
Yes.
Section 2, but rather and these are literally the words that he uses. We're updating and realigning it.
Oh, I love that.
Yeah.
Don't worry about the words that Alito used. The import of it is that the Voting Rights Act is no longer a thing. Like it has no useful purpose anymore. And state legislatures can draw their maps however they want, because of course the court has already sanctioned all partisan gerrymandering. So you can do partisan gerrymandering and you do not have to take race into account. And in fact, if you do, it's probably unconstitutional.
Right. Welcome to Seriously, the podcast that dives into the baffling.
We can't send them to a prison where there's animals, where there's livestock.
The ridiculous.
Like omelets better than sex.
And downright unbelievable political climate in red states like Louisiana.
So we can't go there. There's no vegan jail.
Seriously.
Welcome to Seriously. We're your hosts. I'm Michelle.
And I'm Ellie.
And today there was a lot that happened this week.
It was a doozy of a week.
It was not a good week.
I did launch my law firm on Friday. So that was good. It's been stressful and in process. But that was the one good thing this
Silver
week.
lining.
Yes. But one of the things we're going to talk about, so that was on Friday. It's Sunday now. About 4:30 though on Friday, then the Fifth Circuit's mifepristone and misoprostol telemedicine and mail access order came out, which I was basically like, I can't deal with this.
Yeah.
So we're gonna get into that, but yeah, it was that kind of like the hits keep coming was how the week felt to me.
Well, then I'll start us off with a good news. Seriously.
I also have sort of a funny personal seriously.
Okay.
Yeah.
So my good news is that the Second Circuit Court of Appeals denied Trump's appeal in the E. Jean Carroll defamation case, where she was awarded $83 million.
Yeah.
So of course Trump, I'm sure, is going to, try to take this to the Supreme Court. Yeah, I mean, that's some good news.
Yeah.
E. Jean Carroll is getting at least hopefully closer to
Actually collecting.
Yes.
Yeah. Collecting is always getting a judgment is challenge number one. Collecting is challenge number two.
Yeah, absolutely. This has been going on for a long time.
Yes,
I don't remember. E. Jean Carroll said publicly that Trump sexually assaulted her
In a dressing room.
Yeah, back in the 80s. And then he went on a spree of, calling her lies, her insults, all this stuff.
Also insulting her looks too.
Right.
I mean, obviously sort of an aside, but just like you have no class, man. You have no class. In addition to being like a criminal, you
Yeah.
have no class.
Yes.
Yeah, but he did this both while he was president and also not president, and he's trying to claim presidential immunity. That's what the
basis
what
of
else are they
appeal
gonna
is.
do? So he made the way the judgment got even higher was after a jury had found
Mhm.
that he had defamed her
Mhm.
and that he had sexually assaulted her.
Right.
Then he defamed her again
Mhm.
about the ruling.
he can't help himself.
Correct.
Yes.
So then they went back to the court, and that's how the judgment got even higher.
If folks listening have never heard an interview with E. Jean Carroll,
She's so
oh my
funny.
God, she's hilarious.
And the one with I've Had It is very good.
Yes. Maybe we'll put a link to that in the show notes for people.
Very good.
No, as far as I know, Trump has not said anything. I mean, he would be wise to.
He would be, but he
Heed
would, yeah. I mean,
lawyers'
he
advice.
doesn't normally heed his lawyer's advice.
That's true.
Now he has just a clown car of lawyers who,
Well,
who knows?
they put out a statement that, was like, this is a hoax. I mean, the same,
A hoax.
like whatever.
I mean, that's just one. I think we may have said this before, but it's worth repeating that, like, they have, like, the word hoax has lost all meaning.
It really
Let's go with the way that Trump uses it.
100%. Yeah, that's true. Good Lord. So anyway, I just thought because we are going to share so much bad news.
And about the courts in particular.
Yeah.
Yeah. I mean, the courts failing us, I feel like, is probably the theme of
my lifetime, honestly.
Yeah, but this week too. And we'll see what happens with the abortion access, because there's an emergency appeal pending right now to the Supreme Court. But before we move on to how the courts are failing us and how everything is fucked, then I'll do a quick seriously. So at 5 a.m. on Thursday night, so next day, official day that I no longer work at my old law firm and officially have my own law firm, although this would have been annoying at any time. Then this smoke detector starts going off in my house that the battery is low.
Good Lord.
And people who've never been to my house, this is in my bedroom upstairs, where it has a very, very tall, gabled ceiling. So this smoke detector is about 40 feet in the air. Really. And this has happened before. It actually, at least these batteries seem to be very on time, because my dad's birthday is April 30th. So it was then April 30th. When he had been in town several years ago, this had happened. And so he had helped me with this, getting an enormous ladder and changing it, because it will never stop beeping.
Yeah.
And you have to have an enormous ladder to get up there. So this is going on then all day Friday. About every 30 seconds it's beeping. I have to come downstairs, sleep in my guest room, it's a pillow over my head. Then my brother-in-law very nicely comes over with my nephew to try to help me with this. It's pouring down rain. He goes and rents a ladder at Home Depot. This ladder is so large that we cannot get it up my stairs. It is dripping water all over the stairs. I'm about to slip and fall. The ladder, it is so heavy. We can't get it around the corner to my bedroom, I guess what I say. So I'm really afraid we're going to wreck the house with this huge ladder, and that I'm going to fall trying to hoist this huge ladder, and, there's going to be a much bigger problem. So we have to abort that mission, take the ladder back out, which I teased with my dad, and stepmom was texting, and I was like, it made the beeping seem a lot more tolerable. That at least we hadn't broken a ton of shit in my house that I can't replace. And I didn't have to go to the hospital. So meanwhile, my nephew's what's going on? He's 4 years old, talking. I'm like, get out of the way. Get out of the way. Your dad and I are doing something it's a little bit dangerous. So anyway, so Ian comes back then the next morning with a smaller ladder, and we've gotten it done, folks. The little battery has been changed, because I was also going to have to tell you we're going to need to record somewhere else, and maybe I'm going to have to move out. I'm just going to have to abandon the premises. That nice house? I had to leave it, because there was just no way to change the battery. I also, again, of course, this year was maybe I should just take this fucking smoke detector off the wall. I didn't do that. I've been very responsible about this now the past 2 times that this has happened. It is actually good that there's a smoke detector in my bedroom, which is very high. Yeah. So I will know to wake up and try to get out of the house. But yes, all of my instincts are no, just take that motherfucker. You have no children. If the fire's up there, everything is burned already. You're probably fucked. Just who cares? You don't need to know. Just go out with the flames, man. The fire sign. There's really a burst of glory. Go out with the flames.
There's nothing worse than an incessantly beeping.
So anyway, seriously, that happened. Wow. And now it has been fixed. It's me and everybody else needed one more annoying thing that was happening this week.
As if you're not crazy enough.
Yeah, and nothing makes you feel crazy being oh wait, no, there's a beeping.
Yeah. And then
every 30 seconds.
I cannot stop it. There's nothing I can do.
And it was pouring, so I couldn't even work outside, which is also what I would normally do, at least as a temporary plan. And then being no, this is driving me insane.
Yeah.
I might actually go insane. This might be the final straw. After, So at 4:30 when this is happening, day one of a new law firm, incessant beeping that I can't stop. That's when the I got the text about the Mifepristone decision, and I was like, I can't deal with that.
Yeah.
So I think we should go back in time, though, to Tuesday, or I guess Wednesday,
It was
and talk
Wednesday.
first about the first of the court decisions this week, Louisiana versus Calais case that we've talked about, and how this was pending before the court, and how the way that oral arguments had gone, then it did not seem like it was going to go well for people. For Black people and for voters and for democracy and all of that. And how poor Cleo Fields, bless his heart, probably was going to be out of a job soon. So what happened, Michelle?
All right. So on Wednesday, the Supreme Court struck down the Louisiana congressional map that white voters, although they call themselves in the lawsuit, this is so ridiculous, non-African American voters.
Okay. Are there any in the plaintiffs that are not just white?
I don't fucking know, but let's just call them fucking what they are. They're white.
Yes, right. This is the whole background of this is it's reverse discrimination.
Yeah,
That
yeah.
race shouldn't be able to be used at all in in drawing maps and in voting rights and districting decisions, because the Constitution abhors any distinction on the basis of race.
Yeah.
So just again, for background for people, basically the argument, in a nutshell, was that isn't the Voting Rights Act actually unconstitutional? Doesn't the Voting Rights Act violate the Constitution? Even though it's been in place, for more than 50 years and been reauthorized by Congress and brought real, albeit imperfect, but some real equity to representation in legislatures throughout the states and in Congress.
That's right.
Yeah.
So the ruling on this absurd reverse racism theory, I mean, it guts what remains of the Voting Rights Act.
Again, very little remained of it.
They'd
already gutted most of it. It with Section 5 had already been gutted. This was Section 2. And yeah.
Okay. So Alito wrote the opinion. It was a 6-3 opinion, as folks probably can imagine, with the 3 liberal justices, Kagan, Sotomayor, and Ketanji Brown Jackson in the minority. Alito's opinion says that anytime you want to draw a map that is race conscious in order to implement the promise of the Voting Rights Act and the 15th Amendment, that is what actually violates the Constitution.
Right. Again, because, the Constitution abhors anything that's on the basis of race.
So the thing about the Alito's opinion, we're going to spend much more time on the dissent, but the thing about this opinion is that's so incredibly, I feel like I'm fucking taking crazy
Well,
pills.
it's gaslight. I mean, it's gaslighting at its finest.
100%. Because he's like, they're like, we're not striking down Section 2, but rather and these are literally the words that he uses, we're updating and realigning it.
Oh, I love that.
Yeah.
So I've heard some commentary about this that I think is interesting about whether doing it this way was strategic on Alito and the majority's part, meaning that as opposed to with Dobbs, where they said we are overturning Roe. This is and we're saying it just like that. We're overturning it. And, I have said that to some extent I was glad that they did that rather than pretending like they were not overruling Roe, but really doing something that did overturn Roe. Because then it's harder for people to understand what has happened, right?
Exactly.
It's harder for us to galvanize people. It's harder for people to understand how much their rights have been changed if the court doesn't say what they're really doing.
Yep.
So they did do that, thankfully, with Dobbs.
Yes.
They didn't here.
Nope.
They did the opposite, where they are overruling. They are overturning the Voting Rights Act. There is basically no path forward that the Voting Rights Act has any meetings. Let's pretend that all this precedent is still good precedent and we're just tweaking it or whatever the fuck you just said, realigning and updating.
And realigning.
So people need to understand that. And I think I think people who are well informed do, and I think that will become clear to people. But don't worry about the words that Alito used. The import of it is that the Voting Rights Act is no longer a thing. Like
Yeah.
it has no useful purpose anymore. And state legislatures can draw their maps however they want, because of course the court has already sanctioned all partisan gerrymandering. So you can do partisan gerrymandering and you do not have to take race into account. And in fact, if you do, it's probably unconstitutional.
Right.
So yeah,
Okay.
that's my rant on that.
So the only thing that remains with Section 2 is that if you can somehow or another prove intentional discrimination, then maybe your Section 2 claim can go forward. But that's like going to be nearly impossible because, as we see in Louisiana, as we've talked about with what's happening with Jay Morris and this whole effort to dilute and eliminate power in New Orleans.
There's
As to
always
why-
another rationale.
Exactly.
Yes. I mean, intent is very hard to prove in the
Yeah.
law, but in constitutional situations, and this is also true in the abortion context, like whether the intent or the effect was, to put up the substantial burden, blah, 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 the new Casey test, and they were already fucking us and watering down the rage. Like it was well understood that an intent challenge was basically a dead letter.
Yeah.
And that included, of course, when you had evidence of legislators saying, we're doing this for the intent of trying to prevent people from having abortions.
Yes.
So again, it'll be
End abortion in Mississippi, for example.
Yes. And here they'll be even less clear. Like they kind of couldn't help themselves in the abortion context to grandstand on what they were trying to do, and even still, it was really hard to succeed on an intent
It's a lot
challenge.
Easier to say we're a pro-life state than to say we're an anti-black
That's
state.
right. Yes, and particularly since they can say, we just want more Republicans.
Right.
Like they don't have to actually pretend. Like if the court had not said that all partisan gerrymandering was fine, they'd have to be little more like, we just think this is a fair map. Like we just think that this map makes the most sense. Like they don't even have to do that. All they have to say is, what we're trying to do is get more Republicans because we're Republicans and we'd like more Republicans. If they say that, then they're fine. And of course, this whole time, that the joke of this, is that it's one in the same, like trying to get a more Republican map by necessity is going to be a map that disenfranchises Black voters,
Right.
because Black voters overwhelmingly vote for Democrats. So again, like your intent, either way, whether it's the effect or the intent there, it's going to disenfranchise Black voters. So this goes back, like the original sort of, civil rights talk with all of this is whether it was de facto or de jure, like with desegregating the schools and whatnot. Like at the beginning, it had to be de facto. Over time, then the courts were like, no, it can be de jure. Like, that like that's the effect.
Yeah.
That's what the impact is.
Well, Congress addressed that. So there were a series of cases leading up to this, and I'm not going to go into all the detail on them. I will say that Justice Kagan authored the dissent, but there's a whole lot of the history there that is obviously attributable to Ketanji Brown Jackson.
You mean it in the opinion?
And her dissent.
I'm excited for you to quote some of that. I hear that I haven't read it. I hear that the Kagan dissent is a barn burner.
Yeah. Well, we'll get into that. But before we do that, I do want to say that the fucking white people have been challenging the Voting Rights Act since it was passed.
Well, yeah, and it's the same with, again,
ways.
it's the same with the word. Like, it's like there's been a consistent chipping away.
Right.
Like we've already gotten to a point where the right that and the law is like maybe just on paper already, and so now the Supreme Court has just made it a dead letter.
But what I want to say and point out specifically is that there was a case in which the Supreme Court said, okay, you have to prove intentional discrimination. Then Congress was like, no, that's not what we meant. And so they went back and they amended it to say that the discriminatory effect is what's important. It doesn't have to be intent. So that was the Voting Rights Act was amended in 1982 to deal with the effect of it, not just intent. And because that was reauthorized and signed by Reagan.
I know. And that's like, that is important because, again, not just is it hard to prove intent,
Right.
but also that's not the only thing that matters, right? for sure there should be a path to challenge something where the intent is discriminatory.
Absolutely.
But also, even if the intent is just completely benign, if the effect is that people have been disenfranchised, like en masse, on the basis of race, it doesn't really matter. Like, who cares what your intent was? That's what's happening. Which the other sort of thing I think that's like a side problem with this ruling is that it's also just, again, reinforcing this notion that the Supreme Court keeps doing, that they're in charge of everything.
We're going to get
They're
to
the
that.
deciders.
Yeah.
Congress doesn't really matter. Like the equal branches part, I mean, again, this is a congressional law. This isn't what are the states doing, what are the feds doing. This is a congressional law that has been reauthorized, signed by, George W. Bush, signed by all, Republicans, whatever. The Supreme Court is basically like, Congress, turns out this whole time that you were doing some unconstitutional shit and we're in charge.
Well, there's several points that, including that one that Justice Elena Kagan made in her dissent. And before we jump into it, I just want to say this was the most Jewish thing I've ever read in my entire life. It is chock full of sarcasm, passive aggressiveness.
I like it.
There's like all these asides, things in parentheses. I mean, it's hilarious. And honestly, people should read it. We are going to put a link to it in the show notes. It is very, very, very good. It's her at her most sassy.
I love it.
And I do really appreciate that she authored this dissent and got both of her colleagues to join it without them writing separately, because you can really see the collaboration that happened. And I think that's important because she's joined some decisions that like Ketanji Brown Jackson vehemently opposed and
that's right.
wrote very strong dissents against. So the fact that they could come together on this, I think was great.
Yeah, for sure. I mean, it also reminds me that, I might be secretly Jewish. I forgot that this is a joke with my good friend Gideon. I was telling you about him earlier. When he was visiting me in Eastern Europe, then I was taking him to all these places. So there's all sorts of pickled stuff. I love pickled things. And he's like, "Are you secretly Jewish?" So it's also how I talk and write, with a little bit of a lot of parentheses, a lot of passive aggressiveness, and a lot of sarcasm.
Yeah, exactly.
I hope she was eating some sauerkraut and some good pickled stuff while she was writing it.
So she sort of starts the opinion out really kind of addressing this intentional discrimination standard, this new test that's been created.
Yes, which again is a fake. I mean, it's not a fake test. There will be litigation, I'm sure.
Yeah.
But basically, you're creating an impossible test as the only test, rather than just saying, like, we're not doing this anymore.
Yeah. And her criticism really hinges on the fact that she thinks that the majority is saying something unprecedented, which is that the 15th Amendment has to be construed to impose liability only when the circumstances create strong inference of intentional discrimination. And she says, quote, "And more, the majority makes clear that the circumstances will not do so when the state can point to any remotely plausible race-neutral justification, whether political or non-political, for the district lines that it has drawn." Like, she's just saying outright, like, they could just make up whatever fucking reason they want to.
As we've talked about, I mean, in other contexts, like when we're under a rational base. So like rational basis standard is the opposite of an intent standard, but like the logic of it is the same, right? So like we're going to defer to them unless there is no explanation at all, period, whatsoever,
for why the fuck they were doing
it is to discriminate against Black people.
Yep.
Or on the basis of race. Because I mean, this actually does not, in the South is where this will have the most impact, obviously. Black voters is where this will have the most impact. But it actually is true everywhere. I mean, it will disenfranchise or give states the ability to disenfranchise Latino voters, Asian voters, anywhere where there is like a sizable community of folks who should have a say in their representation. Yeah. Unless the governor and everybody in the legislature is like, the purpose of this law is to make sure that those people don't really get a say with their representation, then you're fine.
Yeah. So she thinks this is bullshit. And so then she kind of talks a lot about this, the history of these bad decisions on intentionality.
Yes.
And how Congress came back and amended. And then she says, from before Section 2 was amended until today, Congress was understood to have constitutional power to ban practices resulting in unequal voting opportunities, irrespective of proof of racial motive. And likewise, Congress was understood to have power to prohibit vote diluting practices, even when a state could proffer some sort of plausible race neutral justification. A lot of her dissent really hinges on this, what you were saying earlier, which is that the court is basically like, they're so critical on the court, we're not supposed to be making law.
Right.
But only when that applies to
Laws they don't like.
But in this case, they're completely overriding what Congress has said very clearly. Is that you have to take into account the effect.
Yes. And again, with like the emphasis on the effect, I think the important thing, when you think about it, it's obvious, is that this is too important, right? It's too important. I think in your personal life where, like someone does something to you that like is very, very harmful. It doesn't really matter if they meant to do it. Like that makes it worse if they meant to do it. But like if the impact on you is really, really harmful, then that needs to be remedied. That's a thing.
Yeah. And actually, we heard last week when we played Senator Royce Duplessis on the floor when he was talking about the low-hanging fruit.
That's right. And all the coding of like, like people are, it's inefficient. It's those are the sort of, that's the pretextual shit that like, you don't even have to be a genius to figure out, what it is that they're saying, because they're basically saying it out loud already, but not in a way that would get you over the threshold even close with the new tests.
So the next thing that she really takes issue with is that and we saw some of this in I think in the Shelby County decision with John Roberts, which is like,
discrimination's over, man. It's over. We've moved on. Yeah. Society's moved on.
Yeah. So in Alito's opinion, he says, quote, things have changed dramatically. And this is pointing to, obviously, an increase in African Americans voting, voter registration, African Americans being able to obtain political office, particularly in the South. And then she says, quote, no doubt that is so in large measure
because of exactly. That was exactly my reaction. I was like, oh, this is like, again, we were like, I want to blow my brains out. Like, correct.
Yeah.
And you know what will be the proof of that is what's coming next, which 100%. I know we're going to talk about. But like we'll see how effective that law has been when we see how many Black people are in Congress in a couple years.
Yeah. I mean, it's the same thing. It's the same stupid argument that the like anti-vaxxers use.
Yeah.
It's like, well, we don't need all of these vaccines because we don't see a lot of cases of, mumps and rubella,
right. Like that's because everybody gets their kids fucking vaccines.
Vaccines, you idiot. Yes.
The Supreme Court's going to do the current test is unworkable, which like is just always triggering to me because it's again like exactly what happened with abortion, where you're like, you made these unworkable tests. You're the guys who made them. And now you're like, well, the test is unworkable. So I guess you have to get rid of the whole thing, which is again exactly what they did.
That we created.
Yes, by getting rid of the whole thing.
Exactly. So the next thing that she really dives into, and I loved this section. I don't have a whole lot of her quotes from it, but this to me was my favorite part.
I hear she read the dissent from the bench.
She did. It's like 60-something pages.
Good for her.
Good for her. So stare decisis. Okay.
Yeah.
So
familiar.
Can you tell people what stare decisis is?
Sure. So it's like just the Latin word for precedent, which some people are probably more familiar with that. But basically that, one of the sort of underlying concepts, like most fundamental concepts in the law, is that precedent matters. If an issue has already been decided by the Supreme Court, then you follow it. So it's why decisions don't get overruled very lightly, or really very commonly, and even bad ones, like that, what we already did is supposed to provide predictability, to everyone to know what the law is. So it's important that the law is not constantly changing. That's the concept.
Yeah.
And this court is not very wedded to what, like, again, like, and the stare decisis idea, I mean, that goes back like hundreds and hundreds and hundreds of years, like long before the founding of the United States. It goes back to like the common law in British times. So this is like very, very fundamental to our system. The foundation of American law, the foundation of British law is based on this.
Yeah.
So she takes on this idea that, like, in this decision, in the majority's opinion, stare decisis is just completely wiped out.
Well, but also they are pretending like they're not doing it.
Exactly.
They don't actually say they're overruling this.
I really liked this section a lot because this is a lot of where she lays out a lot of the history of the cases. I mean, there's 40 years of precedent on this that they go through. So she says, before mutilating jingles, which is one of the cases, the majority should have a super special justification. And then she says, quote, and it does not have one. Not a super special justification, not a special justification, and not even an ordinary decent justification.
I like that. Such a good quote. Which, again, just for context, is because, like, if you're going to throw stare decisis to the wayside and overrule something, there's all sorts of factors it's supposed to meet. But yeah, you're supposed to have a really good fucking reason, and they have none.
Yeah.
It's a little more nuanced than that, but that's in a nutshell.
Yeah. Not
Something
even,
has changed. Like, yeah. There's also,
but they don't. Not even an ordinary decent justification. So next she goes on to talk about the partisan gerrymandering, right? I just want to read this quote and then get your reaction to it. She says, quote, today the majority straight-facedly holds that the Voting Rights Act must be brought low to make the world safe for partisan gerrymandering. For how else, the majority reasons, can we preserve the authority of states to engage in this practice than by stripping minority citizens of their rights to an equal political process? And with that, the majority as much as invites states to embark on a new round of partisan gerrymanders and makes an already bad precedent into one still worse.
It's good. I mean, that really does go to the core of it.
Yeah.
Because like all the decisions the Supreme Court has already sanctioned with partisan gerrymandering are disturbing, right? That like the courts don't have a place in monitoring or, remedying partisan gerrymandering, which is bad, as we all know. So yeah, her point that now, like, anything that's supposed to be like based on racial equity has to get out of the way so that everybody can really get back to the business of doing more partisan gerrymandering, which again is right, because like of what we just said before, that the reality is, if you want as partisan of a map as you can get, it will necessitate you disenfranchising Black voters because they are, historically vote more Democratic. So like, to get to your goal of making things as partisan as possible and making these as Republican friendly as possible, you're going to have to disenfranchise Black voters.
So she lays out a hypothetical which is about to become athetical.
Yeah, that's right. Yeah.
So at the beginning of the dissent, and then uses that as an example to explain the gravity of this decision throughout. And so the example that she gives is, you have pretty much like a circle community in Louisiana in which 90% of the voters there are African American, but also are voting for Democrats. So this is New Orleans, right?
Yeah.
Essentially, that what this decision allows to happen is for that district, which is now being represented, by a Democrat, by an African American, representing the people in that district, can now be, the term is cracked, right? Split into however many pieces of the pie are necessary, like 6 other, pieces. Yeah. And like some of them go to this district and some of them go to that district.
Everybody knows, I think at this point, like what gerrymandering and redistricting looks like, because that's also a big issue that's happening in general right now. So, I mean, these maps and in general end up looking insane. They're not a circle.
Yeah.
They're but some of that historically was for good reason, again, to enfranchise people. So if you were trying to do it so that, some districts like were minority opportunity districts, that's the language, to provides an opportunity in our state that Black people can get elected.
Yeah.
So you have to have some districts that have enough Black people in them. So you might have to draw it in depending on where people live in a weird way, but you can obviously draw it the exact opposite way because it's cracking and packing, right? Those are the terms. So that's always been what the deal is. And now states are being told that they don't need to worry at all about making sure that Black people or again that race is an issue at all in drawing maps. So just draw them however the fuck you want on your partisan principles. So in the South, obviously, everybody be wanting to disenfranchise voters of color anyway, and also wanting to give more opportunities to Republicans. So now it's carte blanche to do that.
Yeah.
So the issue going forward is how many people in Congress, particularly from the South, will be non-white and will be Democrats.
Yeah. Yeah. I mean, Louisiana has never elected a person of color to represent a majority Republican district. That has never happened, and it's never going to.
It has never happened. That's right. It's only happened in districts that were drawn to give that opportunity.
Yeah.
To create a district where there is the majority of voters are of color.
Yeah.
And we see, I mean, everybody in the South sees this, it's just the truth. And this is what Alito and fucking, Roberts, it galls me beyond belief. In election after election here, even among Democrats, then when it comes down to a Black candidate and a white candidate, even white Democrats generally vote for the white person. So, that depends on the race, that depends on whatever, but overall, that is what happens. So you have your runoff, and then in the end, people vote based on race.
Yeah.
If you've then made it so that there are not enough people in any given district who that there are enough voters to elect a Black candidate, assuming the premise that at some point that's really more what people are voting on, it's not going to happen.
Yeah. And so, I mean, what this ultimately is going to mean is that the Black voters in, let's just continue to use Louisiana as an example, are going to be split so that they represent just a small percentage of the districts, the congressional districts, whatever districts, right?
The easiest way to understand it's diluting the votes.
But it's not just that they're never going to have enough, they're never going to have enough voters to elect someone to represent them, but they're also never going to be a large enough percentage of the population of that district for whoever gets elected to ever fucking care about what the needs of their community are, or what they would like to see. So that's the part I think that is so incredibly disturbing. And I just want to read this one quote as Elena Kagan is laying out this situation where she says, quote, "The Callais requirements have thus laid the groundwork for the largest reduction in minority representation since the era following Reconstruction.
Yeah.
Under cover of updating and realigning this greatest of statutes, the majority makes a nullity of Section 2 and threatens a half a century's worth of gains in voting equality."
Yeah, and I was just telling you before this, I was talking to my neighbor yesterday who's not a lawyer, but, is a Black man and very read in general on what's going on in the community and just news in general. And the first thing he said to me about this was it seems like with the court, what they did, I'm very concerned. It seems like they have basically undone, a decades of civil rights work. And I was like, I agree with that 100%.
That's 100% what's happening.
Yeah. The harm to our democracy, I don't think can be really understated, honestly. Because what will exactly happen? We don't know. How quickly will it happen? We don't know.
She says the VRA, quote, was born of the literal blood of Union soldiers and civil rights marchers. It ushered in awe-inspiring change, bringing this nation closer to fulfilling the ideals of democracy and racial equality. And it has been repeatedly and overwhelmingly reauthorized by the people's representatives in Congress. Only they have the right to say it is no longer needed, not the members of this court. I dissent then from this latest chapter in the majority's now complete demolition of the Voting Rights Act.
I just want to say also that makes me want to cry. But
Yeah.
also, I bet that sentence was totally written by the two of them together. It seems like,
Yeah.
right? Like it's like the history part, I'm sure, was more Ketanji Brown Jackson, and the process part more Kagan. But both things very, very true.
And that is what a multiracial
That's right.
Collaboration.
That's right.
can bear,
Correct.
right?
Correct.
Okay.
That's right.
She ends her dissent with this: I dissent because the court betrays its duty to faithfully implement the great statute Congress wrote. I dissent because the court's decision will set back the foundational right Congress granted of racial equality and electoral opportunity. I dissent. Notably, she does not say respectfully. How can you have any respect for these
Exactly.
motherfuckers?
Right. Who not only are doing things that are just so bad,
They have
but
no
they're not,
respect for their colleagues or
and they don't even have respect enough to tell you, like, if you're gonna fuck me to my face. Thing I have said often.
Yeah.
In my personal life, like, like don't try to hide what you're doing.
what is that Judge Judy used to say? Like, don't piss on my leg and tell me it's right.
Yeah,
Yeah.
exactly.
I love
Yeah,
that.
that's not respectful. Nothing about this is respectful.
Okay, so the broader implications immediately in Louisiana, Governor Landry has postponed the election for the U.S. House of Representatives.
Which is wild, let's just say. I mean, first of all, they had already moved these elections back. Remember, they had a whole like special session in order to move the elections back, which we talked about. I was like, it's not gonna, like, this is the Supreme Court's not gonna rule in time that there's going to be enough time to deal with this, which is what just happened. And so in other words, we already fucked with the elections in a way that's gonna be confusing to people and people were worried about. And now they're like, oh wait, yeah, no, it turns out we still don't have enough time to draw a new map and deal with this. So we're gonna like have the elections even later. I mean, I don't even know.
Well, this is what's so fucked up. There's no reason that the Supreme Court couldn't have held on to this decision until June, when it usually decides.
They could have decided it in January, which is, the soonest. And so then there'd be plenty of time. Or they could wait until June. But either way, the court didn't say this has to be done now. Like, Governor Landry could just be like, you know what? We can implement our racist fucking Republican agenda next time.
Yeah.
Like, this does not have to be done now.
Oh, it has to be done now. Just like Jay Morris has to get
That's
rid
right,
of the
exactly.
judges and Calvin.
If not now, when?
Duncan.
Yeah, if not now, when? Yes. Which again, the same thing with the, back to the shit with the courts and Jay Morris, like the doing it now actually creates 1,000 problems that will lead to like confusion, chaos, litigation. Like, just wait a little more time to implement your racist agenda.
Right.
That's the least that we can ask for, folks. Just wait a little bit more time.
You're going to have plenty of time.
The rest of our lives. You'll have the rest of our lives. Yeah.
Because a couple things. One, now all the other contests that were on the ballot for May 16th are going forward. So U.S. Senate, Supreme Court, Public Service Commission.
Which actually it will fuck those also, because then again, voter turnout will be I mean, I did not know if those elections were still going forward, and I'm very well informed. Point being, that's in 2 weeks.
Yeah. Right.
So like, their confusion is not a friend to voters.
No, because also early voting started yesterday.
Yes.
And absentee ballot, like I signed my dad's absentee ballot for this election. My dad already voted for Congress.
This is again why probably they can't do what they're doing. I mean, the votes have already been like, this is already in process.
Yeah.
It's
that's
it's
insane.
unbelievable.
But anyway, people should know all the other contests on May 16th.
Vote
are
and
going.
So the point being, if you were planning to go to the polls on May 16th, which if you weren't planning, you should have been.
Yes.
But now you know, go to the polls on May 16th anyway.
Or vote early, which started
Well, whatever. That's
It's
right.
going
That's right.
through the 9th.
It's left to be determined what is on the ballot that day, but important things will be on the ballot.
Yes, including 5 constitutional amendments.
Yeah.
Yes. This may be your only chance to vote for the candidate of your choice kind of ever in Louisiana ever again.
Yeah. And these,
for these elections, for Public Service Commission, because the Voting Rights Act did not just protect congressional districts, it also protected school board districts, city council districts, Public Service Commission districts, judicial districts. I mean,
yeah, no, you're right. I
It's
mean, I don't
everything.
know. Yeah.
so there is a real possibility that there will never be another Democrat that we could elect in Louisiana for at least the rest of my lifetime. I mean, that's a real possibility that we're looking at.
Obviously, this isn't just happening in Louisiana. I mean, this decision applies nationwide.
Yep.
And other states immediately started being like, well, maybe we can
Yep.
get on this too. Like, it's very late in the game. Many states have already held their primaries or they're underway. But places where
Florida's doing some stuff.
Tennessee
Tennessee's
might,
doing some
Alabama
stuff.
might, yeah, everywhere in the South, spoiler alert, where there's like some plausible, like even remotely plausible chance that they can implement this immediately
Yep.
in order to, because it's not just, of course, right now, the imperative for them is very partisan as well. Like Trump's about to lose the House. I mean, they're gonna lose the House.
Or maybe not. That's why they released this opinion when they did.
That's right.
100% know
100
that.
I agree with
There's
that.
no reason that they couldn't have waited until the end of June to release this, but
No.
that would have gotten them closer to these primaries, to
Think
give as
people-
many
I
states as
think-
possible
That's
the
right.
opportunity to fuck over Black people.
And Democrats. Yes. And I think that like the conventional wisdom at this point, it won't work for 2026 at this point, that Democrats
Probably not.
probably will still get a majority in the House. Beyond that, I mean, all bets are off. Like, races for the House are going to become like races for the Senate, where like basically like structurally it is set up in a way where it's very, very hard for Democrats to win. If you can figure out how to draw maps in your state so that like things are contiguous at all, it's very possible that there will be no Black people.
There is research that's showing that maybe not in this next election, but
Like by 2028.
in the near term, that this could cost Democrats up to 19 House seats. As much of 30% of the Congressional Black Caucus could lose their seats. And this is research by Fair Fight Action and Black Voters Matter. This was research that was released prior to, like leading up to the oral arguments in this case.
I think that is a conservative estimate.
Yeah,
that is
probably.
almost a foregone conclusion.
Yes.
That is 100% happening. It also said, the research also showed that nearly 200 state legislative seats held by Democrats in the South could also just completely be wiped out. We don't have enough votes to do almost anything that we need to help people in Louisiana as it is. And there are a lot of, I mean, there's probably a handful of seats currently held by Black folks, Democrats, that it would be very difficult for them to eliminate.
Yes.
In the heart of New Orleans, in the heart of Shreveport, in the heart of Baton Rouge.
Right.
But anybody who is somewhat contiguous to the suburbs, they're gone.
For sure. This is, again, everybody's sort of like, who knows? But again, just the way that maps work and how big they are and where people are, that like in the South, Atlanta might be the only place where like a Black person is going to be able to be elected to Congress. It's a big enough place and there's enough Black people. Like, I mean, that's terrifying. And also, again, that this tracks, I mean, that's terrifying, period.
Yes.
But also that it tracks partisan.
Yeah.
I mean, are we even able to elect Democrats?
Yeah.
Yeah.
So this is not uplifting information at all, but it's really, really important. And anybody who has been kind of following this, the coverage of it has not been hair on fire enough.
No,
I don't
it has.
think.
I agree with that.
It really has
100%.
not been.
No.
This is completely going to wipe out at almost every level of government the power that Black people have had to represent their communities, to have a voice, to enact policies that are addressing the needs of their communities, and it is going to demolish democratic
Which I guess the positive thing or the call to action to say about that is that, historically when things like this have happened, particularly things that were aimed at or had the effect of disenfranchising Black voters or making voting more difficult, the response has been higher voting. And that's what it has to be here.
100%.
It has to be. Because again, there will be fewer of us in any of these districts. So we all have to vote all of the time.
Yes.
That's the deal.
And if you have a neighbor who is a Republican who's asked you to sign an absentee ballot or maybe drive them to the polls, don't fucking do that anymore.
Yeah.
Don't
Tell them what they can do to help you out is they don't vote.
When the election is, give them the wrong date because you know what? Fuck
them.
Yeah. Yeah.
Fuck them.
Right,
So, Miffy and Misa.
Our next topic. Okay. I'll let me just set this up and then I'll let you riff. Okay. So Friday, a 3-judge panel on the Fifth Circuit Court of Appeals, Judge Kyle Duncan.
Oh, I didn't. Oh, shit. Did he write the opinion?
Yes.
Oh, I didn't know that. Okay.
So this is in
Oh,
the
my God.
Louisiana v. FDA case, which we had previously talked about. It effectively reimposes the requirement that doctors prescribe mifepristone only after having examined a patient in person. So, and it did so on a nationwide basis.
Yes.
So it imposed this nationwide requirement.
Right. So, yeah, procedurally, then it stayed the lower court's denial of the preliminary injunction.
Correct.
So, the lower court in the Western District of Louisiana had said that there would not be a preliminary injunction. The case can go on. The FDA is supposedly doing its thing. Give the FDA time to do their review. But in the interim, things stay the same. The Fifth Circuit has now said, oh no, in the interim, we are staying the denial of the preliminary injunction. So what is in effect is basically a preliminary injunction.
So, and also this ruling took effect immediately.
Yeah, of course.
The argument that was made by Louisiana and accepted by this ridiculous Fifth Circuit is that the state of Louisiana is harmed by its citizens having access to mifepristone because it's unsafe. And the people who are taking it are suffering adverse consequences that require the state to then pay for their medical care. So the thing about this is that the reasoning assumes that there's something more unsafe about mifepristone that's prescribed remotely versus mifepristone that would be prescribed in person outside of Louisiana and then brought into the state.
Yeah, I mean, that's been sort of at the core of what these arguments are, right? That you need an in-person appointment because, maybe you're having an ectopic pregnancy or blah, 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 blah. And the research is the opposite, which is why the telehealth, the FDA's telehealth rule has been in effect, is that in general, then all of those sort of issues can be diagnosed and dealt with a telehealth appointment, that you don't need to in-person examine someone.
Yeah.
If you have a clinician wherever that does a telehealth appointment with you, they can figure that out without examining you in person. And there's tons of research on that.
So just tell us what this means.
Well, so first of all, I guess to back up, I did not know that this was even on appeal to the Fifth Circuit. I didn't know that this was even in the works, that this might happen. It's not that surprising that that Louisiana would have taken this up to the Fifth Circuit because, their best friends are up there, including, as you're saying, Kyle Duncan. Yeah, so for people who don't know, then Kyle Duncan was the lawyer, like himself, on tons of anti-abortion or tons of challenges that we were bringing to abortion restrictions here. He was representing the state as like an outside attorney. And so when he got appointed to the Fifth Circuit, it was like, of
Oh, fuck.
course, yeah.
Yeah.
And he's young. He's like our age. I mean, he's going to be up there for a long time. And this is like, he is anti-abortion to its core. So he
Wasn't
was also
he
on the
in law
COVID.
practice with Mike Johnson?
But they were on those cases together. These people being in power has been like, are we serious? Like, this is really gonna like be a big problem going forward. So like two things on this, like sort of process wise and like and merits wise, is that so what the court had to decide to do this is that Louisiana is likely to prevail on the merits of their challenge, which is the opposite of what the district court had to decide to deny the preliminary injunction. Again, the district court did it also with like a let's see what the FDA does kind of a situation, which is, while that has some of its potential problems anyway, with God knows what this FDA is going to do, is sort of a reasonable way to like thread the needle, like let's just like give the FDA a chance to review their shit and decide if this like, it still seems like it's makes sense from a policy standpoint. Well, the Fifth Circuit has now said, no, we're not going to do that
We're not
because we
waiting.
think we're not waiting at all. We think that Louisiana is likely to prevail on the merits, like no matter what. And as I said to you yesterday, it's not impossible to get the denial of a preliminary injunction overturned. I have done that before. I have tried to do it before and failed. That's something that litigants try to do, but it's hard. It's very hard to get the denial of a preliminary injunction overturned. And of course, that's what the Fifth Circuit, which is why it wasn't even on my radar that this was in the works, because it should be an unlikely event that an appeals court will basically
To the lower
they're
court.
supposed to do that, right?
Yeah.
So this is like again where courts like the Fifth Circuit and sometimes the Supreme Court instead just impose their judgment on what they think that the district court should have done, which that is what they did. I mean, like that's not what they're going to say, but that is what they did. So yeah, out of nowhere, or at least to me out of nowhere, then yeah, the Fifth Circuit has now said that we think Louisiana will win on this eventually, and so much so that we're overturning what the district court has said and we're putting an injunction in place immediately.
That applies to the entire
That's right.
country.
Yeah. So right now, as we speak, and this may not be true by the time this airs, we'll see. But as of now, then telehealth and by mail access to mifepristone is not available in the United States. So, all the doctors that have been sued and or prosecuted in California or New York or wherever, they want to try to provide abortion access to folks down here by telemedicine or through mail provision. They can no longer do that. That is federally outlawed. So not surprisingly, then on Saturday, then there is currently pending an emergency appeal on this to the Supreme Court. We'll see what happens. I know it's this Supreme Court. I mean, the only potentially good thing is that the last time this happened, which was out of Texas, this is out of Kaczmarek's court when he, as the district court, did put it in a nationwide injunction, and the Fifth Circuit, of course, upheld that. Then the Supreme Court intervened, and they stayed that injunction.
Yeah, but Ellie, let me
Yes.
ask you about the details of that case, because what's different is that it seems like in that case, the Supreme Court really could not justify standing
Yes.
on the plaintiffs that brought that case, because they were doctors that
That's right.
were not doing this at all. And their argument was just like, we might have someone that we have to provide care to, that may have gotten mifepristone from another doctor from out of state, blah, 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 blah.
Right.
And then we're having to deal with the
Yes.
consequences of
That's
that.
right. And there was basically no evidence to support that. Like, and that's what sort of gutted that litigation in
Right.
general, although it is actually technically still pending. And that's why then, like, Liz Murrell and them started this other litigation,
Mhm.
which is with like what they think is better standing, which it is better standing.
Which
There
is
are
like
issues.
the state is harmed.
That's right. Which there are issues with that as well. The district court did not agree with, the defendants that there are standing issues for the state, but there are. I
Mhm.
mean, like, again, how much harm is the state really bearing?
Yeah.
But that again is like, that all depends on how you're viewing the facts.
Mhm.
And like the Fifth Circuit and the Supreme Court aren't supposed to be viewing the facts
Mhm.
in any way other than how the district court already has. And the district court hasn't really reviewed the facts. So, I mean, it's all kind of circular, but you are not wrong. It provides a lot of opportunity for a lot of bullshit and a
Mhm.
lot of gaslighting. To me, there's no doubt that although those standing arguments, I think, have some real merit in reality, they're not going to work.
Yeah.
These courts are going to find that the state here has enough harm.
Yeah.
Because again, also Liz Murrell and them have done a really good job of creating a fake record of
Mhm.
this harm. So yeah, the Supreme Court kind of punted on it the last time. We'll see what they do now, and we'll see how long it takes. So, maybe that they just allow this ruling to stand, period, which would mean that indefinitely you cannot legally access mifepristone for the purposes of an abortion in this country. I mean, since this is in the preliminary status, it would be until this case is decided on the merits,
Yeah.
which there was already some risk that on the merits, this case isn't going to go great for us anyway.
Mhm.
So that's very possible. Or hopefully, the Supreme Court, because the like really this is catastrophic for people across the country,
Uh-huh.
they will intervene. So everything is up for grabs right now, and yeah, the upshot is basically that you, you can't in states like Louisiana right now, then where you could have just gotten a doctor from New York or California to prescribe these drugs to you legally and send them to you, even though that's not legal in Louisiana, it was legal in New York
Mhm.
and it was legal under federal law. We should say that like places like Aid Access that are not in this country, uh, are not constrained by federal law. They are brave folks who are not concerned about what our bullshit courts are doing on the federal or state level.
I'm very concerned about this because I think that even if best case scenario is that John Roberts agrees that with like our interpretation, but that still doesn't get us to a majority.
And what we just have to worry about, of course, with this ideological court is that they will do that also while disregarding like what they would do in any other circumstance, right? They should be deferring to the district court, the
Right.
one who actually has looked at the
Mhm.
evidence, and they should be deferring to the agency, being the FDA.
Yeah.
So that's what like the Supreme Court would ordinarily do. And, so if they don't do that, it has harm beyond just this specific situation because it's just a furthering of this court saying that they get to decide
They're the
all the
decider.
time about the everything. Like, doesn't matter what district courts say, and it doesn't matter what agencies say, which, like, for non-lawyers out there might sound kind of wonky, but it's what our system is based on.
Yeah.
It's based on that there are people on the ground who are
Mhm.
experts that have like a lot more purview into the situation, whether it's at the agency level or the district court
Yeah.
level that hears the evidence. So like when you're 50 steps up into the sky, you shouldn't be overturning that willy-nilly. Or it is like increasingly doing that all the time with Congress, with agencies, with district courts. I mean, they don't give a shit basically what anybody is saying. They don't give a shit about
Well, that's
the
because they have
branches of government.
Yeah, I
Yeah.
mean, they've completely packed the court. They are not committed to the separation
No,
of powers.
they're not. The sort of irony here, of course, is that they usually do that. The unitary executive theory, whatever, which is basically the president can do whatever the fuck the president wants.
Yeah.
Agencies are in the executive branch.
Yeah.
So they're never deferring to agencies, although they're supposed to.
Yeah.
But yeah, basically, I mean, the upshot of all of that is that they're just like, we're the decider.
Yeah.
Like for the Supreme Court or the Fifth Circuit or any court to just be like, nah, like we don't think that makes sense what the agency did.
Yeah, but the thing is like, and this is where I get my kind of like tinfoil hat cynicism, like, paranoia, conspiracy theory is that um Trump does not want to be the one
That's right.
to take abortion access away from
I
people.
agree with that. That's why actually I thought that the leaving it up to the FDA, I was kind of okay with.
Yes.
That at the worst, maybe they would slow walk it, even though
Mhm.
they're getting a lot of political pressure from the religious right.
Yeah.
But this is a political out for him, and that the Supreme Court can come in and do what
He doesn't
his
want to do.
base
Yeah,
has been pressuring him to do,
it's
and
true.
he doesn't really want to do.
It's true. It puts the court back into a situation where do they not want to be doing this before the midterms? Again, when we're just being really honest about how these people actually are thinking about things,
Mhm.
these people being our Supreme Court justices who are not supposed to be thinking about things like that. I don't know. Like if if that court is being strategic, they should not.
So, I
should
mean,
not.
people are already going to be motivated by being
Yes.
disenfranchised.
By a bullshit war, by costs going through the roof.
Yeah.
Yeah.
And then you're just, and then you're going to strip people of like the ability to access like, safe.
And immediately without basically any
Medication.
notice to the average person.
Yeah.
So, yeah, I mean, maybe we have that going for us that these people who aren't supposed to be political are very political. We'll see. Again, how long it takes. It's an emergency writ. I mean, it should be decided within days.
Yeah.
I mean, really, it should be decided within hours. Whereas, I mean, with the like this week, like we started out by saying that the courts have failed us. They have, but we always need them still. Like that. I started the week being like these courts are fucked up and bullshit. Then that continued, but now I'm like, okay, well, I mean, the Supreme Court will hopefully intervene.
No,
Like
but
it's just so
we're
it's
gonna
just
be
unbelievable.
disappointed.
We're going to be disappointed. I mean, we do need them, and also they're
I
consistently failing us.
I think that they will intervene here, but I think we will know by the time this
Do you want
airs.
to put some money on that?
Let's put some money on it.
Okay. $50.
Side bet. Okay.
$50.
I don't feel strong. I mean, I will bet $50, but like if it were more than that, I'd be like, how about that? Yeah.
All right, I'm going to be $50 richer the next time we talk to y'all.
It's possible.
We are in a world in which it is very possible that at least one, if not two, currently sitting members of the court resigned during Trump's presidency.
But yeah, you mean because like Alito and Thomas like are likely to resign
Yeah.
this summer.
So that Trump can appoint.
Yes.
And then he would have 5 members of a 9-member court. Like that's crazy.
You mean that he himself will have appointed
Himself would have appointed 5 members. I think that's more than any other
I'm sure.
president.
The bigger problem here is that obviously if they resign, they're going to get not just will new very conservative people be appointed, but that they're going to continue doing what the Trump administration has been doing, where they appoint people who are very young. I mean, and by very young, I mean like in their 40s or maybe 30s. So like they will be on the court for longer than you and I will live. Yes, for longer than we will live. And that the pattern has been to more and more extreme people. I mean, Kyle Duncan will look like a fucking like, easy choice compared to like Emile Beauvais or, what's the asshole at DOJ now? The Todd Blanche. I mean, like people who are just like would never be appointed to be, they've never been judges. They're extremely ideological and they're best friends with Trump, slash, they were his actual lawyers. Like the type, I mean, everyone assumes that if given a chance to replace Alito or Thomas, it will be like the kinds of people that would never have been proposed under any administration ever. And since Congress is no check on anything, that they'll get through. So again, where you're just making a kangaroo system of the system.
It's so
like just
ridiculous.
100%.
I do love the scenario in which Trump does have an opportunity to appoint two new justices, and he does not choose Eileen Cannon, who sucked his dick so fucking hard. And then, like, still gets passed over because she's a fucking woman and he's a misogynist.
I mean, like, he's not going to care about, like,
shit.
representation. Like, there being another woman on the court.
No.
They're going to think that they can get through whoever the fuck they want. So why would he care?
All right. I know we didn't talk about much at the legislature, but I do want to just report on all things that happened this week. It wasn't a busy week for the stuff that we normally cover, but just so folks know, with almost no discussion, House Bill 293, which is Representative Delisha Boyd's bill to try to enact legislation so that people could be protected from employment discrimination based on their sexual orientation or gender identity.
Which, as we have talked about, is the opposite of Cruz's bill. So this would have solved a real problem that, Cruz and the rest of them don't care about. They just care about the fake problem of people being discriminated against because they're discriminating against the LGBTQ community.
That's right. So Representative Boyd has introduced this bill over several years. Last year, we talked to her about why she thinks this is really important. And anyway, that bill was rejected by both Chairwoman Cruz and the other conservatives on the committee. One of the interesting things that came up in the committee hearing was Representative Glorioso was like, I want to make sure that we're not going further than what like the federal government says. So just so folks know, in 2020, the Supreme Court decided Bostock, and they held that discrimination against someone for being gay or transgender is discrimination because of sex under Title VII. And so that means that covered employers cannot make employment decisions based on an employee's sexual orientation or gender identity. So
yeah,
there are already some federal protections.
In Title VII, just so people know, I'm sure most people do, but like that's like on the federal level, that's like your most basic sort of protection from discrimination in the workplace. And it was kind of a surprise at the time when that decision came down. And Gorsuch wrote it, and it was like most people did not expect that case to go well, for the LGBTQ community. But it did, and it did literally expand Title VII's protection.
Yeah.
The way that it interpreted the basis of sex. So I don't know that the court would go that way now, but that's precedent. We know how much they care about it. So yeah, so Glorioso, yes. So there's no way this is going beyond that, I guess, is number one.
Yeah.
Number two, like whatever, fuck you. Like, of course, like states can go beyond what he's just like, but like we don't have to. We only have to do what the feds are saying.
Yeah.
So want to be really sure we're not getting more protection.
That's 100% what he was saying. But the other thing is like, and I think, if I were counseling Representative Boyd, and I would have encouraged her, and maybe I will, to come back next year and just say, like, it is very important for us to codify this in our own law.
Sure.
Because
Hello.
it can
Go away.
Because hello.
it can all go away.
Which actually will give them less of an incentive to do it.
Yeah.
But it's 100% accurate.
Yeah.
And we've talked about that in a million contexts, including me being as generous as I can to Representative Amity and her insanity. It's not a bad idea for there to be some duplication. in state law and in state constitutions, given how likely our Supreme
Tenuous.
Court is, yes,
Yeah.
to actually give two shits about stare decisis.
That's right. Okay. I was listening to the hearing and I just kind of had it playing while I was doing other stuff. And so then another bill came up right afterwards, which was interesting to me. So I want to let people know about it. The next bill that day was House Bill 390. This is by Representative Joy Walters, who's a relatively new representative. And this would have just required an employer to allow one of their workers to take up to 3 working days of unpaid leave from work and
What if you
a 12-month period. Hold on. If the employee is a survivor of domestic abuse, and if that leave is used for any of the following reasons: to seek medical or mental health counseling related to the domestic abuse, to obtain services from any sort of like victim service organization, preparing or participating in civil or criminal proceedings.
Sure, which you need your client. I mean, you need if you're doing something like this, you need your
You need-
client's time.
yeah.
You need them to be available
You need
To
to be able,
testify.
you know,
at the very least.
3 fucking days a year. That bill was rejected again by the same members with literally no debate at all. They were just like, okay, thanks for coming. Thanks for coming and presenting this to us. We don't give a
That's
shit."
wild. They're just like we're doing you the favor of hearing this bill.
Thanks for coming. Give this person the time off that they need to go to court and fucking hold their abuser
Unbelievable.
accountable.
And it doesn't even, presumably, it also doesn't even have to be consecutive. Like you might need one day to go to the fucking doctor, and then need another day, to go to fucking court. That's actually that outrages me. I can't even believe that. It's so unbelievable.
It's so ridiculous. We got to get rid of a lot of people. Exactly.
Yeah, gotta get rid of the pickers and the actual people.
And I just say, like, as a last kind of call to action, white people, you need to start voting with the fucking black people.
Yeah.
Because the black people are being completely shut out of this whole process.
Yes.
With this Supreme Court decision.
We need to come together, figure this out in a way that, we still have some representation. We're at like existential crisis level, folks.
This is literally the constitutional crisis that we have been warned about.
Yes. And like will be now indefinitely.
Okay, so you have a lot of work to do. We're putting a bunch of shit in the show notes, so look at it and click on it and all the things, and we'll be back next week where I'm sure we're going to be talking about a hell of a lot more fuckery.
We will find out who won the bet. I think by next week we'll know who won. And if we don't know by next week, you won the bet. If they haven't ruled by then we can assume you won the bet.
That's right. Okay. In the meantime, Ellie, what are the people supposed to do?
They need to rate, review, and subscribe.
All right. Well, we will be back next week with
maybe good news. I mean,
come on,
we will
Ellie.
never be back with good news,
never
particularly not by next week. But it will be back next week. Let's just leave it at that.
That's it. That's all we can promise.
That's correct. Yeah.
Seriously is presented by Lift Louisiana, a nonprofit organization advocating for reproductive health rights and justice.